Hello everyone, this is Nazrul Islam Khan. I am a lawyer of the Apex Court of Bangladesh. It's my pleasure to appear before you with certain issues of aviation law. I believe this episode shall help you to understand aviation matters in easier way. Today I am going to talk about the nationality rule of aircraft. Let's move on. Well, Article 17 of the Chicago Convention provides aircraft shall have the nationality of the country in which they are registered. An aircraft must not be registered in more than one country. Its ownership or registration may be changed from one state to another in accordance with law of the concerned state. Every aircraft engaged in international navigation must contain its appropriate nationality and registration marks. The nationality and registration marks shall consist of a group of numbers or letters. Nationality mark is assigned by International Civil Aviation Organization. On the other hand, registration mark is given by concerned state in which aircraft is registered. The nationality mark appears before the registration mark, and there is a hyphen between the two. They shall be kept clean and visible at all times, and painted on or permanently affixed to the aircraft. For USA, the nationality mark is N. For United Kingdom, the mark is G. For Bangladesh, the nationality mark is S2. In Bangladesh jurisdiction, Rule 179 of the Civil Aviation Rules 1984 prescribed elaborate provisions regarding location of these marks. Now, remember the time of Chicago Convention. It was negotiated and signed before end of the Second World War. So, the United States and their allies apprehended that their enemy or ex-enemy states could gain control over the aircrafts of a third state and thereby enter USA indirectly. To prevent such scope at the very outset, they have enacted provisions so that foreign investors can't exercise control over aircraft. In USA, an aircraft is eligible for registration if it is owned by an individual citizen or by a partnership firm of which all partners are citizens. In case of a company or corporation, 2/3 control of the board and 75% voting power of the company must reside with citizens. In fact, by reserving 75% share, the government wants to ensure effective control of their citizens. This attempt may be futile in certain circumstances. For instance, if a company allotted 75% share among a large number of citizens, then a single holder of 25% share may be the largest shareholder of the company, and the single holder of 25% share can exercise effective control over the same. In Bangladesh, for registration of an aircraft, the applicant should be a Bangladesh citizen. In case of a company, it should be incorporated under relevant law of this land. For a foreign company, its principal place of business should be located here, and its chairman should also be a Bangladesh citizen. Besides, subject to satisfaction of the Civil Aviation Authority, a foreign company, by virtue of a contract with the government, can register its aircraft. The Civil Aviation Authority maintains a register of aircraft. It contains information regarding registration mark, nationality mark, identification mark given by the manufacturer, date of registration, etc. It also contains information regarding the name, registered address and nationality of owner. The International Civil Aviation Organization prescribed a sample of registration certificate for use by its contracting states. The certificate must be carried in the aircraft at all times. Each contracting state of Chicago Convention undertakes to supply information to other contracting states regarding ownership and registration of a particular aircraft. It has similar obligation to the organization as well. Viewers, we are at the end of this program. We shall appreciate your kind feedback on this episode. In our next episode, we shall bring another topic of aviation law for you. So stay with us. Goodbye.